Mr. President, Your Excellencies, good afternoon, and may it please this honorable court. My name is Julian Angela B. Del Rosario, speaking today on behalf of applicants Ungaras and Uconnect. With me is my co-counsel, Mr. Mark Xavier Libardo, and our off-counsel, Ms. Angela Conejero. For the next 20 minutes, I will be speaking with regard our first two submissions, namely issues A and B1, pertaining to Magentonia's violation of Articles 17 and 19 of the International Covenant on Civil and Political Rights, or the ICCPR. My co-counsel will be speaking for 22 minutes with regard issue B2, which pertains to the prosecution and conviction of Uconnect under Sections 3 and 5 of the Public Information and Data Protection Act, or the PIDPA. We reserve 3 minutes for rebuttal. If you have no preliminary questions or excellencies, I would like to proceed to our first submission. Thank you, Your Excellencies. Search engines and social media sites now play a central role in building one's identity online. This was recognized by the European Court of Human Rights in the 2018 case of ML and WW versus Germany, where the court held in paragraph 97 that search engines, by locating and listing information about an individual, present the public with a profile of that individual. Therefore, it is our submission that when search results are inaccurate, they paint an inaccurate profile of a person. Your Excellencies, Ungaras comes before this court today, invoking Magentonia's international human rights obligation to protect him against unlawful attacks on his reputation. It is applicant's submission that when Magentonia failed to grant Ungaras the remedy of delisting, which is the erasure or blocking of the search results depicting the 2001 Cyanesian Time story, it violated its obligation under Article 17 of the ICCPR. Under this submission, we have 3 main points. First, the search results were inaccurate and thereby constituted unlawful attacks on Ungaras' reputation. Second, there is no public interest in the search results and therefore retaining them was unnecessary. And lastly, the retention of search results was disproportionate. On to our first main point. Your Excellencies, Article 17, Paragraph 1 provides that no one shall be subjected to unlawful attacks on his honor and reputation. In paragraph 4.6 of the Fact, Magentonia enacted the Public Information and Data Protection Act, or the PIDPA, under Section 22 of which provides for the remedies of rectification, erasure, or blocking of data that is irrelevant, incomplete, or inaccurate. This was grounded on Article 7 of the Magentonian Constitution, which is similarly worded as Article 17 of the ICCPR. Therefore, taking all of these pieces of legislation together, it is clear that Magentonia intended to consider inaccurate, irrelevant, or incomplete data about a person on the internet to constitute unlawful attacks on his reputation. Your Excellencies, it is applicant's submission today that these search results were inaccurate. Similar legislation, such as the UK Data Protection Act of 2018, define inaccurate as something that is incorrect or misleading as to any matter of fact. To illustrate, Google has conceded that its search results were inaccurate in December 2018. Whenever the keyword "did the Holocaust really happen" was searched, the top result would come from a white supremacist website. And this is precisely how search results become inaccurate. Similarly, here, Your Excellencies, it is our submission that the search results painted or created an inaccurate profile of Ungaras.
We'll just pause there. So when the legislation talks about inaccurate, it must at least also mean that the facts that are produced in the search are not actually correct. Whereas we know here from the problem that, in fact, those facts were correct. So you couldn't actually say that the facts that were reproduced in the search were inaccurate in the sense that they hadn't happened.
Yes, Your Excellencies, we do concede that the article, at the time it was published, was accurate. However, it is our submission that, as of now, currently, whenever they are republished as search results, they paint an inaccurate profile of Ungaras. And this is because paragraph 1.2 of the facts would show that he was already exonerated as early as 1995. And furthermore, paragraph 1.3 would discuss the context in which these charges were brought. There was systematic political persecution of members of the DPC party which Ungaras founded. Furthermore, that same paragraph discusses that some party leaders of the DPC were forced into exile due to false charges brought against them. And this is precisely what we submit happened to Ungaras. Your Excellencies, the search results were generated precisely because there were two trending posts in the form of the paragraph of the posts discussed in paragraphs 4.1 and 4.4 of the facts. These were the Magentonian Mail expose and the Take Back Mag 200 post. These posts were misleading as they legitimized this false narrative that Ungaras is a corrupt politician who evaded his home state of Cyanesia in order to evade prosecution.
But the test in Section 22 is not misleading. The test is actually inaccurate. It's also incomplete, but I don't think you can shift from inaccurate necessarily to misleading, can you?
Your Excellency, we did point out to the UK Data Protection Act, since the Public Information Data Protection Act does not provide for a definition of inaccurate. We pointed out to similar legislation which defines it as something that is incorrect or misleading.
Well, that might be of great relevance in the United Kingdom, but it's not much relevance before this court.
I understand your concern, Your Excellencies. However, regardless, we still submit that the search results, as of now, whenever they are being used to paint a profile of Ungaras or whenever Ungaras is associated with this content, these are already inaccurate, Your Excellencies, considering that they fail to mention that he was already exonerated, and furthermore, they do not show the context in which these charges were brought. We submit, Your Excellencies, that when people in in April 2018, whenever users of Uconnect would search Ungaras, Ras, and Magentonia, the 2001 Cyanesian Times story would appear very high in the search results. And therefore, we submit that there has been an information asymmetry, Your Excellencies, where the citizens of Magentonia, whenever they search Ras, Ungaras, or Magentonia, they would only see this picture that he was a corrupt politician. And as I have discussed earlier, that is so far from the truth.
You refer to there having been a violation of Article 17, and you referred particularly to Article 17.1. Now, of course, Uconnect is a non-state actor. Where does the responsibility of the state, where does that come in? Does it come in under 17.1 or 17.2?
Your Excellencies, yes, the responsibility of the state under Article 17.2 is to provide adequate legislation and to protect the rights as enshrined in Article 17.1.
And the government would no doubt argue that there is a law which does protect against unlawful in national terms, unlawful attacks on reputation. Why is that not in itself sufficient? Does it not comply with what Article 17.2 says?
Your Excellencies, even though Magentonia already did enact a legislation to this effect, it is our submission that it is also the state's obligation to provide an effective remedy. And here, Your Excellencies, after they enacted this legislation, they failed to grant it correctly to Ungaras after he was entitled to this remedy. As I have discussed earlier, these search results were inaccurate. It created an inaccurate profile of Ungaras, and it legitimized a false narrative that he was a corrupt politician who was trying to evade his home state. And therefore, we submit that these were unlawful attacks on his reputation that the state had a duty to protect, and having failed to grant that remedy of delisting, Magentonia failed to discharge its obligation under Article 17.
There's also a provision, nevertheless, in the law that they don't have to expunge, or if it is in the public interest. And this, as I understand it, is one of the points that was relied on by both by the national courts and by the Commission.
Thank you for that question, Your Excellency. In fact, that takes me to my second main point under this submission, that there was no public interest in the search results, and therefore retaining them was unnecessary. Your Excellencies, as you have stated, paragraph 4.7 of the facts would show that Magentonia relied on this public interest exception to deny Ungaras the remedy of delisting. However, we cite the case of NT1 and NT2 versus Google, decided by the England and Wales High Court of Justice, where they granted the delisting order of a public figure in the form of NT2 because the information was no longer in the public interest after his conviction has been spent. we point you to the concluding statement in paragraph 223 of that case, which says that there is no real need to warn the public of his past offending activities. Your Excellencies, we submit that if we could grant the delisting order of a public figure whose conviction has been spent, then all the more we must grant it to Ungaras, who wasn't even convicted, but was already fully exonerated, Your Excellencies.
Had they included the words that he'd been exonerated, you wouldn't have any complaint to make, is that right?
Yes, Your Excellency. In that case, the search results then would already be accurate. However, in this case, that was not what happened. And furthermore, to further add on this issue on public interest, Your Excellencies, we discussed the 2018 report of the High-Level Expert Group on Fake News and Disinformation Online, which was commissioned by the European Commission. They said that special attention must be paid to inaccurate information during the time of elections. And this is because citizens must have the effective tool in the form of accurate information that will allow them to make an informed vote, and they must have accurate information regarding their candidates. And Your Excellencies, here, since the information contained in the search results was no longer accurate, there was no public interest in them, and in fact, they only undermine public discourse. And having discussed that main point, if you have no further questions, I would like to proceed to my third main point under this submission.
I have one further question. Is there not a balance here between the right to respect for reputation and freedom of expression? You haven't really talked much about freedom of expression.
Thank you, Your Excellencies. And beautifully, once again, it takes me into my third main point under this submission, that the retention of the search results was disproportionate. Your Excellencies, in the case of ML and WW versus Germany, as decided by the European Court of Human Rights in 2018, paragraph 97 discusses that delisting is a balanced remedy as opposed to taking down the original article, because the citizens can still have access to that information. And similarly, here, Your Excellencies, the citizens were not deprived of the access to the information, because we are only asking for the delisting of the search results, particularly in the platform of Uconnect. And therefore, in other platforms such as Google, or in other search engines rather, such as Google or Yahoo, this information would remain available. And furthermore, they can still access it at the very Siamesian Times website. Therefore, balancing the rights here, Your Excellencies, we can protect not only Ungaras's right to reputation, but also the Magentonian citizens' right to vote, while still protecting the citizens' right to freedom of expression and right to seek, receive, or impart information. Your Excellencies, if you have no further questions regarding the proportionality and regarding my other main points under this submission, if I may proceed to my second submission, Your Excellencies. Thank you, Your Excellencies. My second submission concerns the interim injunction that was imposed on Uconnect. For there to be any restriction on the freedom of expression, the three-part test must be met. First, the measure must be prescribed by law. Second, it must pursue legitimate aims. And lastly, it must be necessary and proportionate. Your Excellencies, it is our submission here that the first and third parts of this three-part test were not met. First, this measure was not prescribed by law. Your Excellencies, General Comment Number 34, which interprets Article 19, and which is adopted by the Human Rights Committee, is absolute, that the state must demonstrate the legal basis for any restriction on the freedom of expression. This could be in the form of statute, rules of procedure, or jurisprudence. And here, Your Excellencies, when Magentonia imposed this interim injunction, they had no legal basis. They did not demonstrate the legal basis for where they are sourcing this power. And therefore, Your Excellencies, citizens of Magentonia were not able to foresee the consequences of their conduct. Therefore, this does not meet the first requirement, which is that the restriction to freedom of expression must be prescribed by law.
So, just to take an analogy in relation to that, would you say that, for example, during the situation of a genocide, where it's very clear that social media is being used to encourage the use of genocide, any process to suspend that would be in conflict with the provisions of the International Covenant, unless you could point to a legal requirement, a legal basis for that? Is there some notion of necessity that must underpin that legal requirement in circumstances where, or at least forgive the absence of a legal requirement in circumstances where, for example, a genocide would require or would suggest that it's required for the state to act.
I understand your concern, Your Excellency. As to those cases, then definitely such measure would be warranted. However, we point out that this must still conform to the requisites of prescription by law and likewise of necessity. As to that measure, Your Excellency, we are prepared to concede that the state has an implied power to issue injunctions. However, as you have pointed out, they must meet the necessity and proportionality requirement, because otherwise the state could abuse its power and just grant injunctions of any nature. And Your Excellencies, this is exactly what happened in this case. The state imposed a global injunction which banned the operations of Uconnect, of the entirety of Uconnect in Majantonia. And it is for an indefinite period of time. Your Excellencies, they said that they were only going to lift the injunction after the end of the trial. And this, we submit, is disproportionate both in scope and in the temporal aspect, Your Excellencies. And this takes me to my second main point under this submission, that this interim injunction was disproportionate. Your Excellencies, General Comment number 34 says that any generic ban on a website is by its very nature disproportionate. Furthermore, in the case of Yildirim versus Turkey, decided by the European Court of Human Rights in 2012, the court held that the blocking order on Mr. Yildirim's website, although it does pursue the legitimate aim of protecting the memory of Ataturk, was disproportionate because it rendered large amounts of information inaccessible. And similarly, here, Your Excellencies, this is what happened. 600,000 Majantonian users who were using Uconnect were deprived of a platform for their ideas and opinions, especially during a crucial time, which is elections. This is the time when they must be able to exchange their ideas and expressions about their candidates, about their policies. And therefore, Your Excellencies, when Majantonia blocked this and shut the entire website down, they also took down the lawful expressions, the legitimate content that is being posted by other people on the website.
So, Ms. Del Rosario, is there anything on the record which tells us what could have been done that would be less invasive? Did your client make any suggestions to the court or any proposals of a less invasive but nevertheless effective remedy to prevent the spread of hate speech at this time?
Your Excellencies, we proffer first the takedown of specific content, which is also consistent with paragraph 43 of General Comment number 34. We could have taken down the specific content that was infringing on the rights of the refugees. Furthermore,
but what I'm asking, I'm aware that that would have been a possibility. Is there anything on the record which suggests that your client tendered this to the court as a possibility in relation to address it? Because, of course, the court may not know what the technical capacities of your client would have been in relation to tailoring an appropriate order.
Your Excellencies, there was nothing in the facts that would show that our client, Uconnect, did proffer these other alternative remedies, but we submit that this was because they were also surprised that an interim injunction was suddenly imposed against them. As I have discussed earlier, this injunction that shut down their operations was not foreseeable to them, and therefore they no longer had this opportunity to take down other lesser intrusive means. And
is your argument then that it was disproportionate to apply any injunction at all, or is it simply the injunction which effectively required them to shut down their website that was the problem?
it is the latter that we are submitting here, Your Excellencies.
So you would accept that it was both foreseeable and proportionate that some form of injunctive relief to prevent further posts of this kind was legitimate. Is that right?
Yes, Your Excellency, we would submit that the power to issue an injunction could be an equitable remedy and an implied power of the state. However, here, the shutdown of an entire website for 38 days, Your Excellencies, was simply not foreseeable and also disproportionate. As I was discussing earlier, there are lesser intrusive means such as the takedown of specific content, the prosecution of the authors of the post, and even to address the thousands of new subscribers or the trolls, Majantonia could have ordered the state to issue a two-step verification process in order to avoid the existence of trolls in the website. All of this would be lesser intrusive than shutting down an entire website, which is being used by 600,000 Majantonian users to interact with each other, Your Excellencies. And if you have no further questions with regard to this point, Your Excellencies, I thank you for your time and indulgence. It has been an honor to speak before this Universal Court of Human Rights. Thank you, and may it please the Court.
Thank you very much. Then I'd like to call Mr. Libardo, please.
Mr. President, Your Excellencies, good afternoon and may it please this honorable court. My name is Mark Xavier Libardo, Second Counsel for the applicants Umaras and Uconnect. For the next 22 minutes, I will be discussing our third submission, that the prosecution of Uconnect under Sections 3 and 5 of the PIDPA violated Article 19 of the ICCPR. Your Excellencies, Article 19 imposes an obligation on the part of all state parties to guarantee everyone's right to seek, receive, and impart information, regardless of frontiers and on whatever medium of his choice. And this includes social media platforms. In this case, Your Excellencies, Magentonia prosecuted Uconnect, a social media platform, for allegedly failing to prevent hate speech and for allegedly recklessly disseminating false propaganda, both of which constitutes a restriction on the right to freedom of expression on these platforms. Your Excellencies, in order for these restrictions to be valid under Article 19, it must therefore conform with the three main requisites provided for under the same provision as interpreted or as enunciated by my co-counsel. Firstly, it must be provided by law. Secondly, it must pursue a legitimate aim. And lastly, it must be necessary and proportionate to achieve its aims. Today, Your Excellencies, I will prove before this court that two of these requisites were missing in the prosecution of Uconnect. Firstly, it was not provided by law. And lastly, it was unnecessary and disproportionate to achieve its aims. If this honorable court has no preliminary questions or concerns, I would like to proceed to our first point. Thank you, Your Excellencies. It is our first point, Your Excellencies, that the prosecution of Uconnect under Sections 3 and 5 of the PIDPA violated Article 19 because it was not provided by law. To be considered provided by law, according to the Human Rights Committee in General Comment number 34, the restriction must be foreseeable, it must be clear from the basis or from the wording of the law, and in the way that this law is applied to the facts, what acts and omissions are being prohibited. In this case, Your Excellencies, with respect to the prosecution under Section 3, we submit that the prosecution was not foreseeable because the act for which Uconnect was being prosecuted was not even the same act that was prohibited under Section 3 of the PIDPA. Your Excellencies, according to paragraph 5.5 of the facts, what Section 3 of the PIDPA prohibits is the act of advocating hate speech. Section 3 of the PIDPA actually mimics the wording of Article 20 of the ICCPR, and both of these provisions use the term advocacy. Now, various human rights instruments, such as the UN Rabat Plan of Action, as well as the Camden Principles on Freedom of Expression and Equality, have interpreted the term advocacy as to require intent to incite hostility, discrimination, or violence. In this case, Your Excellencies, Magentonia did not even prosecute Uconnect for having such intent or for advocating hate speech. If I may point, Your Excellencies, to paragraph 6.2.1 of the facts, Uconnect was not being prosecuted for advocating hate speech. Uconnect was being prosecuted for its failure to prevent such an advocacy, which was committed by one of its users. Now, we submit that this is not what is being prohibited under the law. In any case, Your Excellencies, we submit that Uconnect did not have the necessary intent to incite hostility, discrimination, or violence, which makes its prosecution under Section 3 unforeseeable.
So just on that particular point, the fact that the High Court in Magentonia may have formulated its order on the basis that it had failed to prevent advocacy can't really vary the issue before this court, which is the question as to whether it did fall, that its conduct did fall within Section 3, and whether that conduct and whether therefore there is or isn't a breach of Article 19. Would you agree that the way it's formulated in the High Court doesn't affect the jurisdiction of this court? The question remains the same here.
Yes, Your Excellencies. We submit that it is not about the way that the provision is formulated, but rather we take issue with the way that this provision was applied to Uconnect, because to satisfy the requirement of being provided by law, it must not only be clear in the statute itself, but in the way that this law is applied. And it is precisely our submission that it was not foreseeable that the law would be interpreted and applied in this arbitrary manner, Your Excellencies. Your Excellencies, we submit that Uconnect did not have the necessary intent of inciting hostility, discrimination, or violence. To further illustrate the element of intent, Your Excellencies, we proffer the case of Jerseld versus Denmark as decided by the European Court of Human Rights. This case involved a journalist who was convicted of aiding and abetting hate speech when during an interview that he was conducting, one of his interviewees made racially derogatory remarks, Your Excellencies. In that case, Your Excellencies, the European Court of Human Rights, ruled that the conviction of the journalist violated his right to freedom of expression because he was not the author or the speaker of the unlawful content in that case, and that if the interview is taken in its entire context, it showed the lack of intent on the part of the journalist to incite hostility, discrimination, and violence. Similar to Jerseld, Your Excellencies, in this case, Uconnect lacked the necessary intent of inciting such hostility. Uconnect was not the author of the May 26 post, according to paragraph 5.1 of the facts. In fact, it was TBM who was the author of this supposedly unlawful post.
So, Mr. Libardo, on that basis, can a social media platform that is hosting content which clearly constitutes the advocacy of national, racial, or religious hatred ever be found to have infringed Section 3 of the Magentinian legislation?
To clarify that point, Your Excellencies, yes, we do agree that they can still be held liable, but only in the event that they had actual knowledge that a post is already clearly hate speech, and they fail to still take this down, Your Excellencies, because in that way, in such an omission, then we can infer intent on their part to continue advocating such hate speech. But as I will further argue in this case, Your Excellencies, there are other facts and circumstances that would negate such an intent, and in any case, they did remove the May 26 post, Your Excellencies. As I have mentioned, Your Excellencies, they exercised utmost diligence with respect to regulating their platforms. They have already provided for community standards precisely to prevent these kinds of content from ever arising on their platforms and to take them down should they ever arise. They have also provided for a complaints portal mechanism so that they can be notified whenever these kinds of content would arise on their platform and review the same and decide to take it down. And in this case, they did decide to take it down, Your Excellencies. The only problem or the only fault that Magentonia assigns on Uconnect was the fact that it took them 4 days before being able to take this down, which for Magentonia was not an expeditious amount of time. This is despite the fact that Magentonia never even provided for an expeditious removal obligation in Section 3 of the PIDPA, and neither did they provide clear standards or guidelines as to what would constitute expeditious removal. Nevertheless, as I have emphasized, they did decide to take down this post. And this, Your Excellencies, coupled with all of the other factors that I have mentioned, should be enough to negate intent on the part of Uconnect, and to consider them liable under this Section 3 was simply unforeseeable.
You focused on Section 3. You will no doubt come to Section 5, will you? And explain to us whether you say that was also not foreseeable.
Thank you for that question, Your Excellencies. I will now explain, Your Excellencies, Section 5 and the lack of foreseeability as well under the prosecution under this section. Section 5 of the PIDPA, Your Excellencies, prohibits the act of recklessly disseminating false propaganda. Now, it was not clear in the facts how exactly Magentonia found Uconnect reckless with respect to disseminating the May 30 post. What was merely mentioned in paragraph 6.2.2 of the facts was that the May 30 post was indeed false and that it trended for 2 straight days. From this, Your Excellencies, we can infer that Magentonia imposed a duty on the part of the platform to monitor specific content on its platform and decide and to discover its unlawfulness, Your Excellencies. And in failing to do so, Magentonia found Uconnect reckless. We submit, however, that this is not the standard of recklessness that should be applied to an internet intermediary, much less a social media platform such as Uconnect. The failure to fact-check or the failure to verify factual allegations in a specific content, Your Excellencies, is a duty of recklessness that is usually applicable to a traditional publisher. And unlike a traditional publisher, Your Excellencies, Uconnect does not have the same editorial control over the contents on its platform. It does not have the same opportunity to review content prior to publication or even to revise it the same way that traditional publishers do. By the very nature of an internet intermediary such as Uconnect, according to paragraph 3.1 of the facts, Your Excellencies, Uconnect is being used by more than 100 million users worldwide. and each and every one of these 100 million users could simply create and post and share their own content in real time instantaneously. It would simply be impractical, unreasonable, to the point of being even unforeseeable that this standard of monitoring each and every one of these posts would be imposed on an internet intermediary such as Uconnect, Your Excellencies.
Is it for us as an international tribunal to determine what is not reckless, or is this not a matter which is essentially for the national authorities applying the law, subject to some kind of supervisory review to see that the national authorities had not gone too far in finding it reckless?
We do understand that concern, Your Excellencies, and we do agree that there is a certain amount of discretion on the part of the states in interpreting their own statutes. But in order to be considered compliant with the first requirement of being provided by law, this court is empowered to review at least the arbitrariness or the reasonableness of the local court's interpretation of their own statutes. And it is precisely our submission that in this case, applying this standard is unreasonable, and for this reason, that made the prosecution unforeseeable, Your Excellencies. If this honorable court has no further questions.
Am I right to assume that the applicants don't question the applicability of criminal law in this kind of situations?
We will get into the applicability of criminal law, Your Excellencies, precisely in our second submission on proportionality and necessity, Your Excellencies. And to go to that directly, Your Excellencies, it is precisely our second point under this submission that the prosecution, the criminal prosecution of Uconnect was simply unnecessary and disproportionate. To be considered necessary and proportionate, according to the Human Rights Committee in General Comment number 34, it is not enough that it is not enough that the means employed by the state addresses a pressing social need. The means employed by the state must likewise be proportionate. It must not infringe on the right to freedom of expression more than what is necessary in order to achieve its aims. In other words, Your Excellencies, the state must use the least intrusive means available to them in achieving its aims, Your Excellencies. Now, Your Excellencies, this is especially true when we regulate social media platforms, because these platforms provide a very effective medium for everyone to exercise their right to freedom of expression, their right to access information, and their freedom to communicate with each other, all of which are protected under Article 19. This court will inevitably have to balance, Your Excellencies, between the means employed by the state and the rights that would be affected by these means and the rights that would be protected by these means.
So, Mr. Lobato, is it your submission that Section 3 of the PIPDA is unnecessary or disproportionate?
With respect to the necessity of the actual statute itself, Your Excellencies, we have no qualms that it may be necessary in order to pursue the aims of perhaps protecting the rights of certain refugees and of other racial groups.
Is it not, in fact, an express compliance with the international obligation imposed by Article 22?
Yes, Your Excellencies, we do agree with that, and we have no problems with the existence of the statute itself. What we do have a problem with, Your Excellencies, is the way that this was applied to an internet intermediary such as Uconnect. Your Excellencies, we submit.
Sorry, may I just follow up on that? But do you submit that there's a difference in that regard between Section 3 and Section 5?
With respect to...
With respect to necessity and proportionality in relation to the statute on its face?
Well, with respect to that, Your Excellencies, we are not contesting the necessity of both Sections 3 and 5. We are merely, at least with respect to the pressing social need, Your Excellencies. What we are contesting in this case is the necessity and proportionality of holding an intermediary, such as Uconnect, liable under these sections, Your Excellencies. And it is precisely for this court to balance the prosecution of an internet intermediary such as Uconnect, and to assist this court in balancing such a means, Your Excellencies. We offer 4 criteria that was first developed in the case of Delphi AS versus Estonia, as decided by the European Court of Human Rights, that this court can use in assessing the proportionality of any such restriction on the rights of these platforms. The first would be to look at the nature of the intermediary. The second would be to look at the liability of the actual author of the unlawful content. The third would be to look at the means employed by the intermediary to prevent and to take down these kinds of unlawful content. And the fourth would be to look at the consequences of such restrictions on the part of the platform. And if we apply all 4 of these criteria to the facts at hand, we will see, Your Excellencies, that the liability, the criminal liability imposed on the part of Uconnect was simply unnecessary and disproportionate. The first of these criteria would be to look at the nature of the intermediary and the degree of control that it has over the contents in its platform. Your Excellencies, in the case of Delphi AS versus Estonia, where this criterion was first applied, the court in that case indeed held that the liability imposed on the part of the platform therein was in fact proportionate because the platform involved in Delphi AS was an internet news portal. The court noted that the platform in that case actually created, they wrote, and they published their own contents, and they actively invited their own readers to comment their views and opinions on such articles. And so insofar as the comments are concerned, even if they did not have actual control over what the comments will say, or even if they were not the actual authors of the comments, rather, they still exercised a certain degree of influence over what the contents of those comments would contain, considering that it will be in relation to the articles provided for and written by Delphi AS itself. In stark contrast to the Delphi case, Your Excellencies, in this case, the intermediary involved is a social media platform that is a lot more passive with respect to generating content in its platform. In fact, in paragraph 116 of the Delphi AS case itself, the court categorically stated that the analysis that they applied to Delphi AS does not apply to other intermediaries such as social media platforms. And this is precisely because they do not have the same control and influence over what contents will be published on their platforms, Your Excellencies. And so with respect to holding them liable under sections 3 and 5 for the May 26 and the May 30 posts respectively, we submit that it was simply disproportionate and unnecessary to hold them liable for content that they did not even participate in creating or in generating. This leads me to the second point, Your Excellencies, or to the second criterion, which is to look at the possibility of holding the actual author of the comment liable for his own unlawful content. Your Excellencies, this is a recognition of the fact that social media platforms are not the primary culprits when it comes to the unlawful content on its platform. In the case of MTE versus Hungary, MTE Index versus Hungary, Your Excellencies, decided by the European Court of Human Rights, the court in that case held that it was the responsibility and the burden of the state to establish the possibility or impossibility of holding the actual author of the content liable for his own unlawful conduct. In this case, Your Excellencies, there is nothing in the facts that would show that Magentonia has exerted any efforts in establishing the possibility or impossibility of holding the TBM account liable for his own unlawful content.
Mr. Lombardo, the difficulty I have with this line of argument is it doesn't seem to take into account the important purpose that underlies Article 20, Sub 2 of the International Covenant. The International Covenant is concerned about not permitting advocacy for hate speech, not because they particularly want to hold individuals responsible for that, but for a broader public purpose, wouldn't you admit? And that therefore we should distinguish between Section 3 and Section 5 of the PIPDA in both interpreting it and in assessing its compliance with international human rights law, because Section 3 is very much in terms of international human rights law, whereas Section 5 is not. And it just seems to me, therefore, that these arguments you're making weigh differently when one's thinking about Section 3 and Section 5.
We do understand that concern, Your Excellencies, and that takes me squarely to the third criterion that we must consider. We do agree that there is a need to curb hate speech, Your Excellencies, and that is an internationally recognized obligation on the part of states. And to a certain extent, intermediaries must share that burden, Your Excellencies. That much we do agree on. And it is precisely our submission that in this case, Magentonia already implemented so many means and mechanisms precisely to prevent these kinds of hate speech from proliferating in its platform and in taking them down should they ever arise. As I have mentioned in paragraph 3.5 of the facts, they have provided for community standards precisely to prevent their users from posting these kinds of unlawful content.
But I mean, the facts also say that they met on the 27th of May with their lawyers to assess these claims that are made in these posts, and 3 days later they'd still done nothing about it.
We understand that concern, Your Excellencies. We submit that they did, in fact, meet with their lawyers. However, we submit that taking 4 days was justified in this case, Your Excellencies, because the post involved in this case, although it was held to be hate speech, was not clearly unlawful speech as compared to the speech in Delphi, for example. In the case of Delphi AS versus Estonia, the comments involved in Delphi, Your Excellencies, involved actual threats to violence to be committed against the person. Some of these comments even advocated for the lynching of the individual in Delphi, and it posed a more immediate threat to the life and security of the person therein. However, in this case, Your Excellencies, admittedly it does involve hate speech, but the very nature of hate speech, Your Excellencies, is that it is a legally complex issue that even among judges, among the European Court of Human Rights, some of these judges do not even come to an agreement with respect to whether or not a statement already constitutes hate speech or not. As, for example, Your Excellencies, in the case of Ferré versus Belgium, the court was split in that decision, where 4 judges voted in favor of holding the statements of Mr. Ferré as hate speech, whereas 3 judges dissented, Your Excellencies. In this case, Your Excellencies, it would simply be unfair to hold Uconnect liable for failing to take less than 4 days, Your Excellencies, when even eminent jurists would disagree on what would constitute hate speech. And in fact, the very court in this case, the High Court of Magentonia, they themselves took 38 days before resolving the very same issue of the legality of Section 3, Your Excellencies. In other cases, such as in MTE versus Hungary, 9 days was considered expeditious enough for the intermediary to remove the post. And in other statutes provided for under other jurisdictions, as for example in the NetzDG law of Germany, which is quite admittedly very controversial, even that statute itself provides for 2 time periods. When the content is clearly unlawful, the intermediary is given a 24-hour period to remove that post. But when it is not clearly unlawful, such as in this case, the intermediary is given a period of 7 days. And so under these standards, Your Excellencies, it should be understandable that Uconnect would take its time in determining whether or not this is hate speech, precisely to balance not just the rights of the refugees, but the rights of freedom of expression of its users as well.
No doubt these arguments were advanced before the court to suggest that 3 days was expeditious, and the court rejected the argument. Is it for us to substitute our view as to what would count as expedition here, or how are we supposed to assess this?
Your Excellencies, there was nothing in the facts that would suggest that these arguments were put before the court itself, and there was nothing in the facts that would suggest that the High Court itself also considered these arguments. But there is, the fact remains that in Magentonia, Your Excellencies, the Supreme Court of Magentonia, I see that my time has expired. If I may be given a minute.
Please answer the question, yes.
Thank you, Your Excellencies. They were denied the right to appeal, Your Excellencies, and it is for this reason that no other court actually considered these arguments. And in any case, Your Excellencies, we are merely submitting that it is within the powers of this court to determine the reasonableness and the proportionality of interpreting the statutes of these states, Your Excellencies, in relation to the intermediary. And we pray for this court to declare that there has been a violation of Articles 17 and 19 of the Convention. If this honorable court has no further questions or concerns, I thank this court for its time and indulgence. May it please this honorable court.
Thank you very much, Mr. Libardo. Then I would ask for the first counsel on behalf of the respondents, Ms. Tetiana Edlaeva, please to take the floor.
Mr. President, Your Excellencies, dear colleagues, may it please this honorable court. My name is Tatiana Avdeeva, and I, along with my co-agent Ms. Lydia Volkova and Mr. Roman Tokarek, sitting of counsel, have the honor to appear before you today on behalf of Magentonia, respondent in the present dispute. For the following 25 minutes, I will be addressing this court issues A and B1 of the competition case, while my co-agent, taking 18 minutes, will elaborate on the issue B2. We also respectfully allocate 2 minutes for the sorry battle. Your Excellencies, offensive speech, spreading with diabolical speed, converts a social media platform into a fertile ground for propaganda of hatred, violence, and manipulation of human thoughts. In this regard, the state's main task includes protection of its citizens by taking special measures. Such measures can be justified being provided by law, pursuing a legitimate aim, and satisfying the standards of necessity and proportionality. For the convenience of the honorable court, respondent will address the issues following the order pursued by the applicant and will demonstrate that all of the aforementioned requirements were met. Proceeding with the first submission regarding the applicability of the right to be forgotten, we claim that among the attempts to hide mistakes of the past and escape from responsibility for one's failures, nothing will entail more harm than hypocritical silence.
In this regard, Magentonia claims that its decision to deny any rectification, erasure, or blocking of data in search results was properly balanced. First of all, the restriction is provided by law. Secondly, it pursued the legitimate purpose. Thirdly, it met the necessity standard. And finally, the proportionality requirement was also satisfied. Your Excellencies, since applicants did not dispute the first two requirements, we would like to move directly to the necessity part. Here, following the structure which was provided by the applicant's side, we would firstly show this honorable court that information in the search results was accurate and complete. The main distinction shall be drawn between these two terms because for the accuracy standard to be satisfied, the very presence of the sufficient factual basis for the information at stake is enough. In this regard, we would like to refer this honorable court to Novaya Gazeta Voronezh versus Russia case, decided by the European Court on Human Rights. There it was stated that a reliable source can be considered even non-certified, non-original copy of the governmental agency's audit report. In the present dispute, however, the very substantial basis which substantiated the information was the arrest warrant provided by the Cyanesian police and the statements of the Cyanesian police director himself. Therefore, the information at stake shall be treated as an accurate one. Moreover, Your Excellencies, the issue might be raised as to the incompleteness of the information in the search results. What is important to mention in this regard, relying on the Vergzhinovsky and Smoljevsky versus Poland case, that to establish the completeness of information in the search results, the whole scope of those search results on the platform has to be assessed. In this regard, Respondent has two main contentions. First of all, the search functionality of Uconnect itself enabled to access both the Cyanesian time story itself and the acceleration which was provided by the former University of Mr. Angeras. And secondly, Your Excellencies, in this regard, Mr. Ross' own statement clarifying the substance of the Cyanesian time story was available through the primary source of the information, namely Magentonian mail website. Therefore, public was provided with a full image of this person, and this information shall be regarded as a complete one. Consequently, Your Excellencies, the requirement which is provided in the section 22 of the PADPA was met, namely.
But can that be correct, Ms. Avdieva? I mean, it is correct that the information so far as it went was not inaccurate. But in terms of an overall pattern of conduct, it was fatally incomplete in the sense that a core piece of information which completely changed one's perception of the earlier, albeit accurate information, was missing. When one looks at Section 22 of the legislation, surely it means by incomplete the idea that the information that is presented is in fact not an accurate representation of the entire story.
Your Excellency, in this regard, we understand your concern. However, in the aforementioned Vergzhinovsky and Smoljevsky versus Poland case, it was stated that public authorities are not in place to remove the traces of information from the public domain, meaning that if one particular article appeared in 2001 and then was reposted by several users and appeared high on the list of the search results, it is a natural process for any internet search engine, and therefore public authorities cannot intervene in this process because it will cause more harm for the general public and the freedom to receive and impart information. Also, the similar decision was underlined in the Martin versus Hearst Corporation, where it is stated, and I quote, Your Excellencies, that reports on the arrest and the subsequent erasure of the arrest through a criminal erasure statute don't make primary news stories defamatory, because such stories is a historical fact of the arrest warrant existence, and the public still had the right to know about existence of such accusations, despite they were further denied by the court or proven. Consequently, Your Excellencies, we still submit that the information on the search engine was fully complete, and therefore public did not receive the distorted image of the person. With regard to the next argument which was raised by the applicant's side, namely public interest in the data, they requested this honorable court to assess the whole scope of information in its context. In this regard, let me guide you step by step through the facts of the Yuri Bandayevsky versus Belarus case, where applicants, similarly to the present dispute, referred to the very fact that political persecutions took place in his neighboring country, and therefore accusations of bribery against him were based directly on such intimidation and coercion for the criticism of government's opinions. Human Rights Committee in this regard stressed that if there is no other evidence of political persecutions against person, then there is no link apart from penalizing a crime that can be drawn in order to prove that those accusations are inaccurate or false in their nature. Similarly, in the present case, according to the paragraph 1.2 of the compromise, it is stated that the first accusations appeared in 1995, when Mr. Ras even was not a politician. Therefore, the link between political persecutions and those accusations and issuance of the arrest warrant cannot be drawn. Consequently, Your Excellencies, we still submit that given the very fact that information was accurate, recent and complete, and that political persecutions argument cannot be implied by the applicant side, this information remains in the public interest, because this matter always covered the matters of misappropriation of public funds, for instance, or concerns regarding the lawfulness of the politician's income. Therefore, it directly covers the scope of activities which were at stake in the present dispute.
But this phrase of public interest is, to me, it's too vague. For who decides what's in the public interest and what is not?
Your Excellencies, indeed, the public interest has to be decided on the case-by-case basis, and the main reason for that, which is provided by both Human Rights Committee and European Court on Human Rights, is that each particular state and each particular community significantly differs. However, still there are tendencies in the international law which establish that, for instance, one particular actions affect the well-being of the whole society of a particular country. Such actions remain within the sphere of the public interest. And directly misappropriation of university funds and the very fact that Mr. Angeras is the runner for the office at the upcoming parliamentary elections fall within the scope of the public interest exception in the section 22 of the PADPA, which still proves that the information regarding former accusations against him must remain available on the platform.
The very fact that this took place in the case of a leading politician in an election which was just about to occur does require, does it not, that the information that is fed to the public cannot be seen to be misleading, incomplete, inaccurate. And is it not the case that the information here was incomplete and inaccurate, and that therefore there should be some provision which protects the individual, in other words, in a way that doesn't affect adversely the public interest? Public doesn't have an interest in getting information which is inaccurate at the time.
Indeed, Your Excellencies, we agree with the Honourable Court on this point. However, it is important to mention that according to clarification 16 to the competition case, the search results on the matter connected to the Cyanesian Times story also contained exoneration, and therefore public still was provided with a complete version of facts, and therefore this standard was satisfied. Proceeding with the next argument which was raised by the applicant side, namely the proportionality. First of all, applicants relied on the concept of delisting of search results. And secondly, Your Excellencies, they stated that such measure would be an alternative and the least intrusive one in the present dispute. One important point which has to be raised in the present dispute is that Section 22 of the PADPA itself does not prescribe the delisting of search results, and therefore it is unknown to the Macedonian state whether Uconnect in its functionality provides for such a possibility of delisting of search results. Moreover, Your Excellencies, in the primary claims before this Honourable Court, applicants raised the argument regarding the erasure of information, and therefore Respondent deems it necessary to underline that such erasure is impossible in the present dispute, while delisting of information would significantly influence the public interest in this kind of news on the period preceding the parliamentary elections. And also, the very important fact is that still Mr. Ross remains a politician and actively campaigns on the integration of the Cyanesian refugees in Macedonian community. Therefore, remaining the public figure he still can be subjected to criticism with regard to his former activities in the tenure of the university professor. Also, Your Excellencies, in the very basic case on the matter, namely Google's Spain judgment, it was underlined that search engines do not exercise the control over the indexed content, and therefore the removal of such content from the platform is unreasonable, simply because it can be reached from different alternative outlets. In the present dispute, it is well known that this information is already trending on the platform. Therefore, Your Excellencies, merely delisting the part with the Chinese end-time story would seriously hamper the contribution of this information to the debate of public interest. Because, Your Excellencies, people still are aware of this story, however, they will be unable to easily communicate this information and to find both the Chinese end-time story itself and the exoneration which is provided on the matter. Also, Your Excellencies, in case the applicant still requests merely delisting of information pertaining to Chinese end-time story, then the very presence of the exoneration without any further information on the matter would demonstrate the one-sided view on the story, which is also impermissible under the freedom of expression.
I beg your pardon? So the one-sided view, which would be the accurate information that the matter had in fact that had not been proceeded with and the case had been, would be a one-sided view of the story? Why would that be one-sided?
Because, Your Excellency, the arrest warrant was issued by the police authorities, which is a competent authority, namely law enforcement agency of the state, which is empowered to issue such an arrest warrant. However, the university itself merely provided an exoneration which was neither proven nor rejected through the court proceedings on the matter. Therefore, there are merely two sides of the views on the story regarding the misappropriation of university funds, and there is no final decision on the matter. Consequently, the public has right to obtain both versions of the truth and then decide upon which of them is more sufficient.
But I do find this argument intriguing. At the end of the day, the complainant was the university, not the police authorities. They went to the police authorities and said, we've got this complaint. They then said, actually, we're now effectively going to withdraw it and exonerate him. I still don't see why there are two sides to the story. It seems to me you're almost manufacturing two sides to this version. I mean, is it your version that the exoneration, and I don't think it's on the facts, is not a true exoneration?
Respectfully, no, Your Excellencies. We only submit that exoneration was provided to the misconduct in 1995. However, the arrest warrant was issued in 2001, and therefore the newer piece of evidence might be possibly found by the police authorities, and therefore the investigation had to be finished by the law enforcement agency of the state directly.
But it's now 2018.
Pardon me, Your
It's now 2018. I mean, are you suggesting that this is an ongoing investigation?
Your Excellency, the case is silent on the matter. However, still, as was outlined in Fuchsman versus Germany, for instance, it is, although the passage of time makes news less relevant, their suitability for the general public can be restored, for instance, by the suspected involvement of the politician into corruptive scandals, which directly took place in the present dispute. Therefore, we still submit that although the interference with Mr. Ra's right to reputation took place in the present dispute, still, such interference went in compliance with all necessary requirements of Article 17 of the ICCPR. And if I'm of no further assistance for this Honorable Court, I would like to proceed with our second submission regarding the imposition of interim injunction. In this regard, we also elaborate on the fourfold test established in the General Comment number 34 to the Article 19 of the ICCPR. It also involves the provided by law, legitimate aim, necessity and proportionality standards, and we would respond directly to the allegations which were raised by the applicants. With regard to the legality part, we acknowledge that prior restraints are compatible with freedom of expression, and in this regard, respondent would like to refer this court to Cumhuriyet Vakfı versus Turkey case, where it is stated that measures merely providing a provisional protection can be granted at the discretion of the judge. Respondent both in their applicants both in their written memorials and in their oral submissions referred this court to the cases versus Turkey decided by the European Court of Human Rights, such as Cengiz versus Turkey and Yildirim versus Turkey. In this regard, the distinction has to be made between those cases and the present dispute. First of all, because the scope of dissemination of information is significantly higher through the Yukon Act, and the speech is manifestly illegal one. and secondly, the nature of the measure differs. With regard to the scope, for instance, in Cengiz versus Turkey, only 10 videos allegedly insulting the memory of Atatürk, which is prohibited under Turkish legislation, took place, while in the present dispute, according to paragraph 5.4 of the competition case, several thousands of new accounts shared and commented on potentially manifestly illegal content, and therefore it became trending on the platform and appeared even on the live feeds of users who were not subscribed to the TBM's account itself. And secondly, Your Excellencies, in both Cengiz and Your Dream, the permanent blocking took place, namely the measure itself bore the character of sanction, and therefore it has to be established in the criminal court or the court of criminal procedure. In the present case, however, it was only the temporary injunction which preserved the balance pending the outcome of the case, and therefore certain margin of appreciation can be granted to the judicial authorities with regard to imposition of such measures.
I think that the applicants, as I understand it, don't say that it would have been either unforeseeable or disproportionate to have some kind of interim injunction. The problem here, as I see it, is the nature of the injunction that is granted. You say it's an interim one, but it's a very long interim injunction since it extended until the end of the trial, which was over a month later. And secondly, the nature, that it didn't just prevent further posts being made of a similar kind, it was an injunction which effectively closed down the site. I really like you to focus on that part of the argument, namely the disproportionality of the measure.
Indeed, Your Excellencies, proceeding with the proportionality of the measure, we refer you to the test established in Cumhuriyet Vakfi versus Turkey case for assessing the necessity and proportionality of interim measures. It involves the scope and duration of interim measure, as well as the proper balance between protected and restricted rights. With regard to the scope, wholesale website blocking is considered permissible under international law when particular kinds of the content are present on the platform and such platform is unable to control over the entire scope of materials, which might possibly lead to harmful consequences. Those types of content involve child pornography, copyright infringements, hate crimes, or incitements to violence or hostility. In the present dispute, violations of the kind were established, while Uconnect demonstrated a strong inability to take care over the entire volume of infringing materials on the platform. For instance, even the usual notice and takedown system took 5 days, from the 26th to 30th of May, to establish unlawfulness of only one publication authored by TBM.
But we do have in the clarifications, the points of clarifications, clarity under point 21, that Uconnect did have the capacity to block particular items or particular issues, which would have been a much more proportionate response to impose an injunction on Uconnect in relation to this hate speech in this particular context. Why was that? Why would that not have been a much more proportionate response, and why is a complete blocking proportionate, given that there were alternatives of that sort?
Your Excellencies, our answer to the question is twofold. First of all, targeted blocking policies are inapplicable in the present dispute due to their ineffectiveness. Namely, either blocking of particular accounts or particular publications cannot prevent from speedy reappearance and either circumvention of the filtered content. In this regard, Your Excellencies, the great example is J19 and J20 versus Facebook Island case, where it is stated that the platform is unable to control the entire volume of materials which is provided by the users, and this directly leads to the harmful consequences for both targeted individuals, namely the refugees at the most vulnerable group in the country, and also all people who receive the manipulated version of facts, for instance, false propaganda in pre-election period. And the second point which can be raised in this regard is comparison with Germany, where the publications of anti-refugee character were trending and promoting through the platform, and simply slow and ineffective response of Facebook at that particular instance led to harmful consequences. Namely, people even came to the streets and have beaten refugees to death. Therefore, Your Excellencies, in order to avoid similar conclusions of the present dispute, we still submit that the injunction was proportionate toward the scope of infringing materials which distributed through the platform faster than ever before and could not be effectively controlled by Uconnect. Also, Your Excellencies, the line can be drawn with the Myanmar example, where even the promotion of content through the platform embodied itself in the alleged genocide, and it was directly attributed to the availability of the platform and ineffectiveness of the targeted blocking policies against either particular accounts or particular posts which were made by the users.
What had prompted the application here in the first place, and what was what had prompted the court to behave in the way it did was the fact that there was a forthcoming election, and that it was that had sparked all these posts relating to the position of Mr. Das and the situation so far as the Majortonians are concerned, or rather, sorry, the Senatians are concerned. Why was it proportionate, therefore, to apply the injunction not just until the election had taken place, when one would imagine the whole matter would die down because the matter would have been resolved, but to the end of the trial, which was in July, in other words, more than a month later? Where was the proportionality of that?
Your Excellencies, in this regard, two main legitimate aims were pursued by the Majortonian government while imposing the injunction. First of all, protection of voters from certain forms of intimidation and coercion, and secondly, protection of refugees as the most vulnerable group in the country. And in this regard, the publication of 26th of May directly embodied the tendency in the posts which appear on Uconnect and speedily circulate on this media platform, therefore leading to harmful consequences and description of refugees even as terrorists. Therefore, it was necessary to establish through the judicial order which kind of the content is present, and then to implement appropriate systems in the Uconnect's functioning in order to enable this media platform to react more effectively and faster on the appearance of such publications. For instance, after the assessment of this content, even such terms as bottom feeders could be easily implemented in the automatic word-based filtering system, and then the team of human reviewers would effectively react on those publications, assessing them. However, Your Excellencies, until the conclusion of the trial, such conclusion upon those publications was simply impossible, and therefore we still submit that the injunction imposed on Uconnect in pre-election period, and which lasted until the conclusion of the trial on those publications, was proportionate. And finally, Your Excellencies, we submit that no harmful consequences occurred for intermediary in this particular period, because the proper balance between protected and restricted rights was established. Namely, the right of people who distributed and reported information was not violated, because Uconnect was only one of the social media platforms which were available in Macedonia. However, several other outlets could be accessed. Those outlets, contrary to the Uconnect itself, won't contain such harmful materials as, for instance, hate speech and false propaganda, which are prohibited under Macedonian legislation. Therefore, Your Excellencies, we submit that the injunction was legal, necessary, and proportionate, complied with all necessary requirements of Article 19 of the ICCPR. And I see that my time is up. Therefore, if I am of no further assistance for this honorable court, I would like to give the floor to my co-agent and Mike with the court.
Thank you very much, Ms. Adieva. Then Ms. Lydia Volkova, please.
Mr. President, Your Excellencies, dear colleagues, may it please this honorable court. My name is Lydia Volkova, and I have the great honor to appear before you today, proceeding with submissions of Macedonia, respondent in the present proceeding. For the following 18 minutes, I will cover the remaining submission of Macedonia, namely issue B2, regarding full compliance of Macedonia's prosecution and conviction of Uconnect with criteria established in Article 19 of the ICCPR. Your Excellencies, freedom of expression provides possibilities for everyone to make his or her voice heard on the internet. However, skillfully designed hate speech occupies people's minds and diminishes the values of humankind, living democracy bleeding. Thus, being not absolute, freedom of expression may face certain restrictions, in case they are provided by law, pursue legitimate aim, being necessary and proportionate. And during the course of our submission, we will prove that Macedonia complied with all above-mentioned requirements and lawfully restricted UK Act's rights under Article 19. And as to the legality of the interference, and as was mentioned by the applicant, Section 3 of PIDPA confirms the international principles as it is designed in a manner similar to Article 20, Clause 2 of the ICCPR. And in the case at hand, UK Act was prosecuted for non-removal of the publication which amounted to hate speech, however, had a duty to do so. And moreover, Your Excellencies, UK Act itself recognized this duty as follows from para 3.5 of the competition case, where the community standards of UK Act are mentioned. And moreover, Your Excellencies, applicants referred this honorable court to the case where the actual author of the publication, which amounted to hate speech, was prosecuted, stating that the intent requirement shall be met. And indeed, Your Excellencies, Rabat Plan of Actions includes the intent requirement in the 6-part test. However, this intent shall be present only for the original author of the speaker, while intermediaries are liable when they fail to act expeditiously and to remove clearly unlawful content without delay. And as to the Section 5 of PIDPA, we also state that this section is clearly foreseeable, as it clearly prohibits the dissemination of statements which demonstrate a reckless disregard to verifiable information. And moreover, Your Excellencies, applicants stated that Section 5 of PIDPA does not include the duty to expeditiously remove this publication. And in this regard, we would like to draw the attention of Gruppero Radio versus Switzerland, where it is stated that when a company is a professional in a particular sphere, and I quote, it is expected to seek and inform itself fully about the rules applicable on the matter. And in this regard, UK Act was expected to know about the expeditious requirement for the removal of clearly unlawful publications.
Before you proceed, Ms. Volkova, is it your submission that in relation to Section 5 of the PIPDA, that there's an obligation on every social media platform to verify every factual claim that is made on the platform?
Respectfully, no, Your Excellency. However, we submit that in the case at hand, UK Act had a duty to verify the publication of 30th of May, and with your permission, it would be addressed further in the necessity requirement. And if Your Excellencies have no question with regard to the legality part, we will move to the necessity. And here, we also rely on criteria established in Delphi AS versus Estonia, analyzing firstly, context and content of the publication, secondly, measures which were applied, and finally, consequences of the publication for intermediary. However, before proceeding with the analysis of the posts, we will reply on the applicant's argument regarding the liability of the actual author. And here we state that the case is silent whether TBM was prosecuted or not, and in this regard, this argument was built simply on the assumptions of the applicant. And moreover, Your Excellency, the latest judgment of European Court on Human Rights on this matter, namely Johannes versus Norway, stated that sometimes even governmental agencies are unable to find a proper account holder of the anonymous account. And in this regard, we state that in any event, only UK Act shall be held liable for these two publications. And proceeding with the analysis of the 26th of May post, we state that manifestly unlawful publications involve incitement to hostility, discrimination, or violence. And thus, firstly, we will prove that the post of 26th of May was a manifestly illegal one, namely incitement to hostility, and secondly, that UK Act did not act expeditiously while removing it. And with regard to the incitement to hostility, we rely on criteria established in Rabat Plan of Actions, as well as by European Court on Human Rights in Princip versus Switzerland. Thus, the most crucial point in the case at hand is context of the publication, its nature and wording, and finally, its possibility to lead to harmful consequences. And as to the context of the publication, we state that usually the presence of tense social or political background leads to consider of the existence of hate speech. And in this regard, European Court on Human Rights, for instance, in Le Pen versus France, recognized the problems of integration of immigrants as a tense background for offensive expressions. And in the case at hand, approximately 65,000 Cyanesians crossed Macedonian border due to the violence and intimidation suffered in their neighboring country. and social conflict arose when the society divided in two parts with regard to the different points of view on refugees' employment. And in particular, Alexis Lin, the leader of the main opposition party, stated that Sinaisan refugees are the major strain for Macedoonian economy and the main cause of the crisis in Macedonia. And in this regard, we state that the background for the publication of 26th of May was a tense one, and thus this post was capable to lead to hostility. Moving to the nature and wording of the publication, we state that the publication of 26th of May included offensive statements such as the stateless bottom feeders, they were kicked out from Sinaisia for plotting terrorist attacks, and thus this publication demonized Sinaisan refugees and insulted disturbing feelings in Macedonia. And similarly to Balsi Teli di Kiana versus Lithuania, the post of 26th of May depicted Sinaisan refugees as the perpetrators of severe crimes, namely terrorists, and thus this publication was capable to cause serious concerns in Macedonian society.
Section 3 doesn't only prohibit incitement to discrimination, hostility, or violence. It prohibits advocacy of national, racial, or religious hatred that constitutes incitement. You focused on the incitement part, but less on the question of whether there was advocacy here.
Your Excellency, we stated in the case at hand there was an advocacy of national hatred which embodied in the incitement to hostility. Namely, hostility is a manifestation of hatred, and thus this publication of 26th of May incited the Macedonian community to hostility against Sinaisan refugees.
Does it require any form of intent at all, the advocacy? Does it not require that you should intend to incite?
Your Excellency, as was mentioned beforehand, intent is required only for the original author of the publication, while Eucan Act is liable for omission, namely for non-removal of the publication of 26th of May, non-expeditious removal. And with your permission, moving to the consequences of the publication, we state that according to ECHR in Kunan versus Germany, even the likelihood of harmful consequences is sufficient for establishing incitement. And HRC in Malcolm Ross versus Canada stated that an expression can be regarded as incitement even without causal link to actual consequences when the risk of such consequences is reasonable to anticipate. And under Respondent's view, the publication of 26th of May had an undoubtful capacity to produce feelings of threat, anxiety, and fear in Macedonian society. The very fact that this publication was shared multiple times and that similar substance might also possibly appear on Eucan Act proves that this publication strengthened the already existing tense background in Macedonia. And we would like to provide to this honorable court the example of Germany, where users used Facebook as a tool to share rumors portraying refugees as a threat, which further resulted into violence made against them offline. And there, even if only a minority of users expressed these harsh statements, once these statements dominated the newsfeed and started trending, as in the case at hand, this could have consequences for everyone else. And similarly, in the case at hand, this publication was made in such an intimidating environment and thus was capable to lead to hostility. And if Your Excellencies have no question with regard to the substance of the publication, we will move to the measures applied by Eucan Act with regard to this post.
I still remain unclear in my mind, with Ms. Volkova, as to why it is that you submit that Eucan Act had actually breached Section 3 by advocating racial hatred and incitement to violence. You know, for every user and for everybody who understands the role of Eucan Act, they are not the publisher or the author of this article. They are just a facilitator of the space. So why on your submission does that constitute advocacy, even if they're aware of it? Why are they then actually advocating the content of it?
Your Excellency, we state that intermediary does not act expeditiously for removal of the publication which amounts to incitement to hostility, as in the case at hand. It accepts this content as its own and thus is liable for dissemination of this content on the platform.
Well, I could understand that you could construct a criminal offence of that nature, which is to say, you know, a knowing hosting of a post that advocates racial hatred will constitute a criminal offence. But what you're having to make the case out here is that in the absence of that language in the criminal offence, that we should read the criminal offence to have that implication. And why do you say that is so? Why should we give it that broad interpretation?
Your Excellency, because Kyiv-Mohyla was also obliged to comply with international principles on this matter, and for instance in Delphi Airs versus Estonia and in other cases regarding the liability of intermediaries, it was stated that intermediaries are also obliged to comply with the domestic legislation. However, they also have the duty to expeditiously remove these publications, which are prohibited, for instance, by Section 3 of PIDPA, as in the case at hand. And with your permission, moving to the measures applied to...
I would like your clarification on the responsibility of intermediaries concerning the authors who are unknown. Actually, do you think that the intermediaries always should be responsible when the authors are unknown?
Respectfully, no, Your Excellency. Intermediaries are responsible only when they fail to act expeditiously and to remove the publication, even of made by unknown authors. And in this regard, Kyiv-Mohyla should be held liable in the case at hand. And with regard to the measures applied by Kyiv-Mohyla, applicants provided this honorable court with the example of MTU versus Hungary, when they stated that the publication was removed 9 days after notification, which was regarded expeditiously. However, in paragraph 15 of this judgment, it is stated that on 17th February, the platform received the notification regarding the existence and unlawfulness of this publication and then removed this post in 1 day. And in this regard, the example provided by the applicants plays in favor of respondent. And moreover, Your Excellencies, for instance, in Delphi Airs versus Estonia, clearly unlawful publication was removed 1 day after notification, while in Pichel versus Sweden, decided in 2017, doubtful content, namely defamatory statements, were also removed 1 day after notification. And in the latest judgment of European Court on Human Rights on this matter, namely Johannes versus Norway, offensive statements, which even did not amount to hate speech, were removed 17 seconds after notification. And in this regard, we state that intermediary must be held liable if it fails to act expeditiously. And in this regard, given the unlawfulness of the publication of 26th of May and amount of complaint which Kyiv-Mohyla received by the users, it should have acted expeditiously and to remove this publication 24 hours after the notification. Consequently, Your Excellencies, it cannot be said that the publication of 26th of May is compatible with spirit of tolerance and justice. And if Your Excellencies have no question with regard to the post of 26th of May, we will move to the 30th of May TBM's publication. And here, applicants stated that Macedonian government wanted to impose a duty on Kyiv-Mohyla to monitor the activity of TBM on this matter. However, we state that, we would like to draw the attention of this honorable court on paragraph 5.2 of the competition case, where it is stated that on 30th of May, on the very same day when this publication appeared, Kyiv-Mohyla decided whether to suspend or terminate the account of this user. And in this regard, the platform had an obligation to verify the publication of 30th of May and then to remove it. And alternatively, Your Excellency, we state that Kyiv-Mohyla had a duty not of a general monitoring, however, of a specific monitoring of the content posted by TBM. This obligation arises when intermediary received at least one complaint regarding previous violations made by a particular user, and thus the platform is obliged to monitor the activity of this user with regard to further potential violations which can be made. And in the case at hand, Kyiv-Mohyla was properly notified regarding the publication of 26th of May and thus was obliged to monitor the activity of TBM whether this user would not post other publications which are unlawful. And in this regard, we state that Kyiv-Mohyla should be held liable for non-removal of the publication of 30th of May.
So where did that obligation in relation to TBM come from? What is are you asserting that that's an obligation that arises under Macedonian law?
Your Excellency, unfortunately, the case is silent on the matter of the existence of such legislation. However, first of all, with regard to the assessment of an account, each intermediary, when it decides whether to suspend or terminate the account of a particular user, it shall verify the publications which are made and to prove that there are violations which are made by this user, or to prove the absence of such violations. And with regard to the specific monitoring, this obligation arises from general practice of states, namely Austria, when this obligation exists in the court practice.
But are you trying to suggest that that kind of an obligation arises in order to avoid liability under Section 5? In other words, the requirement that you haven't acted recklessly requires that in all circumstances where you think a user may be from time to time posting things that you think are in breach of your community standards, you, in order not to be reckless, you have to investigate every single post they put up, the factual veracity of it?
Your Excellency, let me clarify the position of Respondent on this matter. In the case at hand, Kyiv-Mohyla was prosecuted and then convicted under Section 5 of PIDPA, as it has a clear knowledge regarding the unlawfulness of this publication. And thus, we do not impose a duty on Kyiv-Mohyla to monitor the activity of each particular user on the platform. However, sometimes this obligation exists, such as the obligation of a specific monitoring, which was provided by the Respondent.
So just take me to where where Uconnect knew that this allegation about the University of Magentonia study was false.
Your Excellency, the case is silent when this information appeared. However, after the conclusion of the trial, this information was provided by Magentonian courts. However, when Uconnect had the obligation to verify the publication of TBM, it was obliged to check whether this information is true or not. And in this regard, Your Excellencies, we state that prosecution and conviction of Uconnect under Sections 3 and 5 of PIDPA was necessary in a democratic society. And briefly summarizing our argument on proportionality, we state that the fine imposed on Uconnect was not disproportionate, and there was no possibility of the occurrence of a chilling effect in the case at hand, as Uconnect was fined only for $100,000 for two single publications, for two publications which amounted to violation of PIDPA. And in this regard, Your Excellencies, we state that Magentonia did not violate Article 19 of the ICCPR.
Okay. In judging the proportionality of the penalty, are we entitled to take account of the fact that there had been an injunction which had been applied since the beginning of June, with the consequence that, so it is said, that Uconnect lost $20 million as a result in business because its platform had been shut down? Is that relevant to our consideration of the proportionality of the fine that was ultimately imposed?
Your Excellency, I see that my time is up, but may I
Yeah,
answer
but
your
please
question?
answer the question.
Your Excellency, first of all, we state that an injunction imposed on Uconnect did not amount to a punishment and had only a procedural character. And moreover, Your Excellencies, the losses of Uconnect could not amount to 200,000 millions, as only 200,000 is the maximum loss of Uconnect for the injunction which lasted during the trial. And in this regard, Your Excellencies, we state that prosecution and conviction of Uconnect was completely proportionate, as Uconnect indeed violated Article 3 and 5 of PIDPA, and thus should be held liable. And if I'm in no further assistance for this court, this concludes the submission of Respondent, and may it please the court.
Thank you very much, Ms. Volkova. Then I would like to invite the applicants to reply. There'll be one speaker. Is that that's you? Thank you very much. Please, Ms. Del Rosario.
Your Excellencies, good afternoon once again. For our rebuttals, we make 3 points. First, respondents claim that the information showed in Uconnect had the complete picture, because both the cyanation time story and the clarificatory statement appeared therein. However, they failed to address my contention on the information asymmetry that was created in Uconnect. Paragraph 13 of the clarification state that trending influences the search results. Paragraph 32 clarifies that this clarificatory statement did not trend in Uconnect. And paragraph 4.3 and 4.4 of the facts would tell us that the cyanation time story was the one that was highly viewed, highly shared, and appeared high on the search results. Therefore, Your Excellencies, if we have 50 search results and 49 of them were showing the 2001 cyanation time story, that is not a complete picture that is being given to the Magentonian citizens. I would like to cite this Google Analytics study saying that 90% of internet users only look at the first page of search results. We for Your Excellencies, that when we delist these search results, then finally the clarificatory statement can finally appear and rank high in the search results. And this clarificatory statement shows the complete picture. Because when Ungaras clarifies that he was exonerated, he inevitably discusses that he was once charged with a warrant of arrest. On to our second point, Your Excellencies. Respondents say that the blocking of a website meets international standards. I don't know what international standards these are, but general comment number 34 is clear. Any ban on a website is disproportionate. We stress that the subject of this injunction is only 2 posts, Your Excellencies. And yes, they were shared by thousands of users in Uconnect, but still, as compared to the 600,000 other users who were sharing lawful content, it is clear that this measure is disproportionate. We point out that even the refugees' expressions were gagged in this case. Furthermore, they miscite the case of J19 and J20 versus Facebook Ireland. They claim that the case was ruled based on the impossibility to control large volumes of content. However, they were citing the defendant's submissions and not the court's assessment. There, the court ruled based on actual notice. And lastly, Your Excellencies, as Mr. President Bratza as well as Judge Cato Reagan have cited, what Section 3 prohibits is advocacy, and this requires intent. Therefore, the claim of the respondents that the element of intent can be dispensed with for intermediaries cannot be found in any part of Section 3 of the PIDPA. The conviction of Uconnect was therefore unforeseeable, and such an arbitrary interpretation would fail to properly apprise Uconnect and other platforms, Your Excellencies, and this would lead to over-censorship, which is incompatible with what the covenant seeks. Your Excellencies, all of this taken together, we ask this court to rule that Majantonia violated Article 17 and 19 of the ICCPR. Thank you, and may it please the
Thank you
court.
very much. Please, Ms. Alieva.
Your Excellencies, applicants for their rebuttal raised 4 points, and therefore we deem it necessary to respond to all of them. First of all, with regard to the delisting of search results, we still refer this honorable court to Vakzhinovsky and Smoljevsky case, because all search results in the platform depict the traces of the story and the passage of time with which it appeared on the platform, and therefore public authorities cannot interfere in such process, as well as cannot public authorities interfere in the process of trending of the content and promotion of such content. Moreover, still, the delisting function of Uconnect is not coming from the competition case, and therefore we are not aware of whether such measure is applicable at all, while in their claims, applicants primarily raised the argument regarding the erasure of the whole information pertaining to Chinese end-time story, which still is impossible in the present case. With regard to the imposition of interim injunction upon the 2 publications, Your Excellencies, those publications were trending on the platform and therefore appeared on live feeds of users who were even not subscribed to TBM's account. Moreover, in this regard, it is important to mention that other followers of the similar policy which was promoted by the TBM's account could possibly post the same amount of infringing materials, which would hamper both the election results and bring harm to refugees. With regard to the J19 and J20 versus Facebook Ireland, Your Excellencies, the arguments which was raised by the defense still was accepted by the court at that instance, and the general monitoring obligation was not imposed on Facebook because it is impossible for a platform to control the entire materials on the platform. And finally, with regard to the nature of the secondary liability, indeed, Rabat plan of actions established the intent, however, as was mentioned by my co-agent, only for the original author, while it is in the nature of the secondary liability to be imposed on intermediary. Pardon me, I see that my time is up. May I finish the sentence? To be imposed on intermediary only in case when such intermediary does not act expeditiously. This concludes the respondent's story battle, and may it please this honorable court.
Thank you very much indeed.
All rise. The judges will now step outside to deliberate upon the outcome of the case. After their discussion,